You suffered really bad injuries as a result of an accident or maybe medical malpractice, and now you believe you have a very strong case. You start your lawsuit, but before your lawsuit actually gets up off the ground, you find out that the defense makes a motion to dismiss your case instead of providing an answer to the allegations. You want to know what this is all about? Come join me for a moment as I share with you some remarkable information. Hi, I'm Gerry Oginski. I'm a New York medical malpractice and personal injury trial lawyer practicing law here in the state of New York. So now you believe you suffered injury as a result of someone else's carelessness. And it could be a car accident or medical malpractice. And now you hire an attorney to bring a lawsuit on your behalf. Your attorney goes ahead, files a lawsuit, files the papers, starts the lawsuit. And now you expect that everything's going to go smoothly and you know you're going to be successful in your case. Why? Because you believe you have a strong, valid case. Well, you get a call from your attorney who tells you, listen, things aren't going so well. We hit a bump in the road right after we started the case. And you say, what do you mean? He said, it turns out the defense, rather than going ahead and answering the allegations to your lawsuit, turned around and made a request to dismiss your case before anything even got started. And you ask, how could they possibly do that? They don't know any of the facts. They don't know the details. How could they possibly ask the court to dismiss the case if they don't know any of the details? As a preemptive strategy, the defense may try and get your case dismissed to try and knock you right out before you ever have a chance to get through the discovery phase of your lawsuit. Now, the defense will have to put in legal argument and legal reasoning as to why your case doesn't have merit. They're going to have to get experts, oftentimes, to support their claim that your case doesn't have merit and doesn't belong in the court system. And if the judge agrees, now you're out. You're done. Your case is over before it even started. And now you've got a big problem. On the other hand, there is the possibility that a judge will turn around and say, listen, this is a bit premature. The judge may determine that this is a factual dispute that ultimately needs to be resolved by a jury rather than an issue of law for the court to decide upon. In that instance, the court will then allow the case to proceed forward. But don't be surprised if your attorney picks up the phone, calls you, and says, listen, the defense made a motion to dismiss your case right after we started it before serving an answer to the complaint. So why do I share this great information with you? I share it with you just to teach you how these types of cases work here in the state of New York. You know, I realize you're watching this because you've got questions or concerns about your own particular matter. Well, if your matter did happen here in New York and you've got legal questions, what I encourage you to do is, you know what I'm going to say, right? Pick up the phone and call me. I can answer your legal questions. This is what I do every single day, and I'd love to talk to you. You can reach me at 516-487-8207 or by email at Gerry, Gerry, at oginski-law.com. That's it for today's quick video. I'm Gerry Oginski. Have a great day.